Well, good evening, everyone. I'm Bill Goldstein. I'm the programming curator here at Roosevelt House, and I welcome you on behalf of Harold Holzer, who is the director of Roosevelt House, and also Jennifer Rabb, the president of Hunter College. I'm very excited to introduce Jeff Stone. He is a professor of law at my alma mater, not the law school. I did not go that far, but I did graduate from the University of Chicago, and I'm particularly pleased that he's here because so much of what he writes about in his book traces the context, really, of my adult life. And I think of the time when I graduated from the University of Chicago, and then after that, sitting in Tudor City Park, which was near where I worked in 1986, and reading the Bowers v. Hardwick decision in the New York Times, and feeling very much that my place in this American society was marginal at best, and incredulous, really, at what I was reading in the newspaper that morning about this decision, and feeling very hopeless. And so many years later, that situation changed. I felt very different about the Supreme Court and about what the Constitution had to say about gay men, about lesbians, and about many of the subjects that Jeff Stone addresses in his book. So here we were, or here I was in 1986, a very different story for the next 25 or almost 30 years. And as Jeff Stone makes clear in his book, that moment, those 30 years are now on the cusp of a different era, perhaps, and we have very different things to look forward to than we might have thought even 9 months ago. So without further ado, I introduce Jeff Stone to talk about his book, Sex and the Constitution.
Thank you, Bill. I'm delighted to be here. This book, as Bill said, explores the history of sex, religion, and law from the ancient world through the 21st century. And my goal in writing it, a task that took basically a decade, although I did many other things at the same time, was to illuminate the process by which American law has called into question the constitutionality of a broad range of government regulations of sexually related behavior, including contraception, abortion, obscenity, sodomy, and same-sex marriage. And in the course of this process, the Supreme Court has found itself confronting fundamental questions about the nature of sexual freedom, the meaning of liberty, equality, and privacy, the legitimacy of government efforts to dictate sexual morality, and perhaps particularly the appropriate role of religion in public life. Now, to introduce Sex and the Constitution to you this evening, I thought, on the one hand, I might do a broad sweep trying to touch upon all of the different issues that the book touches upon. But I decided instead it's probably more sensible to focus on just one of those issues, to go into a little bit more depth, to give you a glimpse of the nature and the scope of the book. And to do that, I want to tell you a story. And it's a story about what for 4 decades now has been one of the most bitterly divisive issues in American politics, and that is the Supreme Court's 1973 decision in Roe versus Wade. Opponents of Roe maintain that the court disingenuously invented a constitutional right in that decision out of whole cloth and without any legitimate justification, in which they completely transformed our traditions as a nation. Supporters of Roe v. Wade maintain that it was a perfectly sound decision that correctly recognized a fundamental constitutional right. Now, whether one agrees or disagrees with Roe v. Wade, contemporary understandings of the decision and of its historical origins are often confused and incomplete. The story of how we got to Roe v. Wade, like the story of how we got to Brown v. Board of Education, or how we got to Obergefell versus Hodges, the same-sex marriage decision, is important to remember because it gives both content and context to the debates that we continue to have to this day. So let us begin more or less at the beginning. At the time our Constitution was drafted, abortion was often relied upon by single and widowed women in particular to avoid the consequences of illegitimate births. in that era, contrary to what people today tend to believe, abortion, or at least abortion before quickening, which is the time at which a woman first feels movement, which is roughly 4.5 months into pregnancy, abortion before that moment was perfectly legal. Indeed, this had been the unbroken state of the law in Western culture as far back as history goes. Although the Church in the Middle Ages condemned abortion as a sin, the law did not treat abortion as a crime even then. To the contrary, those who did not share the faith were free to do as they wished. Abortion was also common and legal in England in the years leading up to the American Revolution. As Lady Caroline Fox wrote to her husband in the 1740s, upon learning that she was pregnant for the third time in as many years, I'm certainly breeding. I took a great deal of physic yesterday in hopes to make it go away. Soon thereafter, she wrote her husband that she'd been successful, noting, "Is not that clever?" Well, at this time, in fact, a wide variety of female pills were readily available in London shops for the purpose of inducing abortion. The American colonies embraced the same approach to abortion as the English common law, and abortion before quickening was both common and legal in America. Moreover, even abortion after quickening was almost never punished. Now, over the course of the 19th century, abortion became ever more common with the passage of time. This was evident in the fact that the birth rate in the United States fell dramatically from 1800 to 1900. In the colonial era, the average family had 9 children. By 1900, that number was down to only 3. The reason for this change, the impetus for the change, was clear. In the agrarian world of the 18th century, children were an important economic asset. But by the end of the 19th century, with the greater urbanization and industrialization, children were increasingly seen as a financial burden that could cause the family's economic ruin. There was a need for control. Thus, for most families, birth control had become essential. And because contraception was generally unreliable in those days, abortion was seen as a critical way of managing family size. Indeed, by the middle of the 19th century, approximately 20% of all pregnancies ended in abortion, in legal abortion. At this time, abortifacients were readily available from mail-order firms and from pharmacists. Daily newspapers regularly ran ads for abortifacients, and those who provided abortion services did so quite openly. The flamboyant Anne Lohman Restel of New York, for example, who was popularly known as Madame Restel, maintained a highly profitable abortion business serving a genteel middle and upper class clientele. She touted her celebrated powers for married ladies, and like many of her competitors, she broadly advertised in the penny press of the day. The general acceptance of abortion as an appropriate method of managing family size first began to change in the latter part of the 19th century. 2 factors in particular contributed to this development. First, religious perspectives on abortion began to change during the evangelical explosion of the Second Great Awakening in that first half of the 19th century. The traditional Protestant conception of the fetus assumed that it was not alive until the point of quickening. Abandoning that view, evangelicals during the Second Great Awakening began to preach that a separate, distinct, and precious life came into being at the moment of conception. Second, medical professionals in this era increasingly came to the view, based partly on religion and partly on what I dare say was half-baked science, that human life begins at conception. A professor at the University of Pennsylvania, for example, published a pamphlet in which he confidently asserted that newly conceived embryos could think and could perceive right from wrong. And in the late 1850s, the Boston doctor and religious moralist Horatio Storer initiated a concerted physicians' crusade against abortion. Storer decried the growing frequency of abortion and maintained that the primary explanation of the phenomenon was the general demoralization of women. Storer insisted that many women who had abortions died, or either immediately or shortly thereafter, as a result of the moral shock from the very thought of what they had done, and others were driven to insanity. Storer charged that children born to a woman after she had had an abortion were often born deformed or diseased, and that they too, therefore, bore the burden of their mother's heinous act. Storer emphatically rejected the notion that a woman should be able to decide this question for herself, because, he explained, during pregnancy, a woman's mind is, quote, prone to derangement. As a result of Storer's campaign, in 1859, the newly founded American Medical Association adopted a resolution condemning abortion at every stage of gestation, except when doctors found that it was necessary to save the life of the woman. Over the next several decades, the AMA, working hand in hand with religious moralists during the late 19th century's social purity movement, launched an aggressive and successful campaign to rid the nation not only of abortion, but also of contraception. As the leading voices of this movement explained, the sole purpose of woman is to produce children, and women, therefore, must remain within that God-given sphere. By the end of the 19th century, in a complete reversal of the world of the framers, every state had enacted legislation prohibiting the distribution of any product designed for the purpose of contraception, and every state had enacted legislation prohibiting abortion at any stage of pregnancy unless a doctor certified that the abortion was necessary to save the life of the woman. Thus, for the first time in Western history, abortion was unlawful even before quickening, and women who had abortions were now themselves subject to criminal prosecution. Opponents of birth control insisted in this era that the issue was simple. If a woman did not want to get pregnant, then she should not do anything that might get her pregnant. It was as simple as that. But despite the threat of criminal punishment, the medical profession's often perverse warnings about the dangers of abortion and the preaching of religious moralists, women in the late 19th century continued to seek abortions in record numbers. By the turn of the 20th century, approximately 2 million women had illegal abortions each year, and almost a third of all pregnancies ended in abortion. Now, though, for the first time in history, these abortions had to be performed illegally, in secret, and in unsafe circumstances, and by much less reliable practitioners than in the past. By the 1950s, with improvements in contraception, which was now increasingly, but still not universally, legal, the number of unwanted pregnancies gradually declined. But even then, approximately 1 million women each year resorted to illegal abortions. The vast majority of these women continued to turn either to self-induced abortion or to the dark and often forbidding world of the back alley abortion. Women who resorted to self-induced abortion typically relied on such methods as throwing themselves down a flight of stairs or ingesting, douching with, or inserting into themselves a chilling variety of chemicals and toxins ranging from bleach to turpentine to gunpowder. Knitting needles, crochet hooks, scissors, and coat hangers were among the tools most commonly used by women who attempted to self-abort. Approximately 30% of all illegal abortions at that time, the 1950s, were self-induced. Women who sought abortions from back alley abortionists encountered similar horrors. To find someone to perform an illegal abortion, women often had to rely on tips from elevator operators, taxicab drivers, salesmen, and the like. Because of the clandestine nature of illegal abortions, the very process of finding an abortionist was dangerous and terrifying. Women who sought back alley abortions were often blindfolded, taken to remote areas, and passed off to people they did not know and could not even see during the entire process. Such abortions were performed not only in secret offices and hotel rooms, but also in dank bathrooms, in the back seats of cars, and literally in back alleys. The vast majority of these abortions were performed either by persons with limited medical training or, more often, by rank amateurs, including elevator operators, butchers, prostitutes, barbers, and unskilled laborers. In the 1960s, an average of more than 200 women died each year as a result of botched illegal abortions. In addition to those who died in the course of illegal abortions, many thousands others suffered serious illness or injury. The stories of women who suffered through this nightmare are legion. One woman recalled to a fellow college student who had had an illegal abortion was too frightened to tell anyone what she had done. She locked herself in the bathroom in her dorm and quietly bled to death. In another incident, 28-year-old Geraldine Santoro bled to death on the floor of a Connecticut hotel room after she and her former lover attempted an abortion on their own. The former lover, who had no medical experience, used a textbook and some borrowed tools. When things went terribly wrong, he fled the scene, and Santoro died alone. The occasional visibility of such incidents, and they were occasionally visible because most people were ashamed and frightened of what they had done and because it was illegal, so the occasional visibility of such incidents led some religious organizations that had previously been silent on abortion to address the issue more directly. Protestant churches varied in their opinions. The United Methodist Church, for example, acknowledged the sanctity of unborn human life. But nonetheless, upon understanding more about the reality of abortion, it proclaimed that because we are equally bound to respect the sacredness of the life and well-being of the woman, for whom devastating damage may result from an unwanted pregnancy, we support the removal of abortion from the criminal code. Similarly, in 1968, the American Baptist Convention came to the conclusion that abortion should be a matter of, quote, responsible, personal decision. The Catholic Church, on the other hand, insisted that abortion was always and unequivocally forbidden, even when necessary to save the life of the woman. This led the politics of abortion to play out in interesting and surprising ways. Because Catholics had traditionally identified with the Democratic Party, and because Catholics were more likely to oppose abortion, Republicans at this time were more pro-abortion than Democrats. Although we often forget this fact, it's interesting to recall that in early 1972, 59% of Democrats and 68% of Republicans thought that the decision to have an abortion should be made solely by a woman and her physician. Indeed, Republican politicians spearheaded some of the earliest efforts to liberalize abortion laws. Barry Goldwater, for example, one of the Republican Party's conservative icons, supported abortion rights. And in 1967, California Governor Ronald Reagan signed a bill liberalizing that state's abortion laws. But because of other, more liberal elements of the Democratic Party itself was officially more pro-abortion than the Republican Party. Seeing an opportunity to draw disaffected Catholics from the Democratic Party, Republican leaders began to move towards a more anti-abortion stance. They knew that if they could succeed in this effort, they could bring about a profound shift in American politics. This strategy was clearly evident in President Richard Nixon's policies during the 1972 election. With a clear sense of the political ramifications of the abortion issue, Nixon embraced an anti-abortion stance for the first time in a strategic effort to draw Catholic voters into the Republican camp. Nixon knew what he was doing. In the 1972 election, large numbers of Catholics who were prepared to cast single-issue votes on the issue of abortion voted Republican for the first time in their lives. This helped Nixon to win an overwhelming victory in that year's presidential election. At roughly the same time, though, the rising voice of the women's movement began to shape public discourse on abortion. In February of 1969, for example, Betty Friedan, the founding president of the National Organization for Women, delivered a rousing address in Chicago at what was billed as the first national conference on abortion laws. Friedan declared that there is, quote, no freedom, no equality possible for women until we assert and demand the control of our own bodies, over our own reproductive processes. At the end of the conference, the participants founded the National Association for Repeal of Abortion Laws, NARAL, on the premise that what was needed was a complete overhaul of America's abortion laws. Later that same year, Planned Parenthood and the American Public Health Association also called for repeal of America's abortion laws and declared abortion to be a fundamental personal right of women. As these organizations moved to the forefront of national debate, the law began to change. In 1970, 4 states, Hawaii, Alaska, Washington, and New York, legalized abortion in the first trimester for the first time, thus restoring the law to more or less what it had been at the time that our Constitution was adopted. Opponents of these laws, however, quickly mobilized their forces. And adding fuel to the fire, in the early 1972 year, Congress approved the Equal Rights Amendment and submitted it to the states for ratification. This immediately led religious and conservative activists to tie the issue of abortion to even larger conflicts about the appropriate role of women in American society and to the meaning of so-called family values. Suddenly, as a consequence, the legislative progress on abortion that had begun only a few years earlier ground to a halt. Despite growing and clear majority support for legalizing abortion, no state legislature now acted on that view. Indeed, in light of this response, the New York legislature voted to override the law it had adopted 2 years earlier and to, again, criminalize abortion in the state of New York. And it was only Republican Governor Nelson Rockefeller's veto of that bill that left abortion legal in this state. Legislators, frankly, knew all too well that although a substantial majority of citizens supported legalizing abortion, when Election Day rolled around, committed single-issue voters could effectively vote them out of office. Faced with this sudden paralysis in the legislative arena, pro-choice advocates began for the first time to think about challenging the constitutionality of anti-abortion laws in the courts. Initially, this seemed a long shot, because in the words of New York Times columnist Linda Greenhouse, the idea of a constitutional right of abortion seemed somewhat illusory. But with legislative change effectively blocked across the nation, the courts now seemed the only realistic alternative. In 1970, after the Connecticut legislature repeatedly refused to amend its 19th century anti-abortion statute, a group of women activists formed a new organization, Women versus Connecticut, to challenge the constitutionality of the law. 6 weeks after Women versus Connecticut filed its complaint in federal court on behalf of 858 women plaintiffs, the federal court in Connecticut held that the Connecticut law violated the United States Constitution. Judge Edward Lombard, a conservative Eisenhower appointee, held that in this law, quote, Connecticut trespasses unjustifiably on the personal privacy and liberty of its female citizens in violation of our Constitution, and that the state's purported interests in banning abortion are insufficient to take from the woman the decision that she, as the appropriate decision maker, must be free to choose herself. Cases challenging anti-abortion laws now started popping up everywhere. In Georgia, a group of 24 plaintiffs, including doctors, nurses, and members of the clergy, challenged the constitutionality of Georgia's anti-abortion statute. The federal court in Georgia also held this statute unconstitutional, explaining that the constitutional concept of personal liberty embodies a right of privacy that is broad enough to include the decision of a woman to terminate an unwanted pregnancy. At roughly the same time in Texas, Linda Coffey and Sarah Weddington, recent graduates of the University of Texas Law School, teamed up with a plaintiff identified only as Jane Roe to challenge the Texas anti-abortion statute. On June 17, 1970, the federal court in Texas held that the Texas law also violated the fundamental right of women to decide for themselves whether or not to have children. A year later, the Supreme Court of the United States announced that it would hear the case of Roe v. Wade. Now, many Americans today think of Roe v. Wade as a radical left-wing decision, but that was not at all the view at the time. By 1973, a substantial majority of Americans supported the right of a woman to terminate an unwanted pregnancy, and Gallup polls showed that 2 out of 3 Americans think abortion should be a matter for decision solely between a woman and her physician. Moreover, as we've seen, the lower federal courts were already moving sharply in a direction that anticipated the decision in Roe v. Wade. In an overwhelming 7-2 decision, the Supreme Court held that these lower courts were correct, and that the Constitution did indeed guarantee a woman the right to decide for herself whether or not to bear a child. Strikingly, 3 of the 4 justices recently appointed to the Supreme Court by Richard Nixon, who had dedicated himself to appointing conservative justices, joined the decision. Indeed, without their support, Roe would have come out the other way. That Warren Burger, Harry Blackmun, and Lewis Powell joined Justices Douglas, Brennan, Stewart, and Marshall in Roe speaks volumes about the mainstream nature of the decision at the time. The plain and simple fact is that at the time that Roe was decided, the justices did not view the abortion issue as posing a particularly divisive ideological question. Although the justices certainly understood the stakes in the case, none of them would have imagined that Roe would later become to be a central flashpoint of American politics. Now, this understanding of Roe at the time is consistent with both the news coverage and the public reaction. Because Lyndon Johnson died on the same day that the court handed down its decision in Roe, newspapers, magazines, and news shows treated Roe as only a secondary headline. U.S. News & World Report, for example, did not even mention Roe on the front page of that week's magazine. As the editors observed 40 years later, quote, the far-reaching effects of the decision simply weren't evident at the time. This view was also consistent with the editorials and commentary about Roe, which were overwhelmingly approving. Even newspapers in traditionally conservative states took this view. The Atlanta Constitution, for example, characterized the decision as realistic and appropriate. And the San Antonio Light gushed that although the ruling might not be perfect, it was as close to it as humanly possible. Moreover, the American people clearly endorsed the decision. In polls taken after Roe v. Wade, only 40% of Americans disapproved of the decision. And to put that in perspective, it's useful to compare the public's reaction to Roe with its reaction to other, more controversial decisions. In 1962, for example, after the Supreme Court held that prayer in public schools was unconstitutional, 79% of Americans disapproved of the decision. In 1967, after the court held laws prohibiting interracial marriage unconstitutional, 72% of Americans disapproved. In 2010, after the court held that laws limiting corporate campaign expenditures were unconstitutional, 80% of Americans disapproved. But only 40% of Americans disapproved of Roe. An additional measure of just how uncontroversial Roe was at the time is the fact that when President Gerald Ford nominated John Paul Stevens to succeed Justice Douglas in 1973, not a single senator asked Stevens a question about Roe or about the issue of abortion. It simply wasn't thought to be controversial. Even most evangelicals did not challenge the decision. For in 1973, most evangelicals still regarded abortion as a Catholic issue. The one group that did strongly condemn Roe from the very moment of the decision were Catholics, who disapproved of the decision by a margin of 56 to 40%. Indeed, within days of the decision, thousands of telegrams and letters of protest from Catholics began pouring into the court. Many of them form letters from Catholic school students denouncing the justices as murderers and butchers. The vast majority of these letters were addressed to either Justice Blackmun, who was the author of the opinion, or to Justice Brennan, the court's only Catholic justice, for whom, by the way, I was serving as a law clerk at the time. And I want to tell you two anecdotes about that moment because they are illuminating about the life of the Supreme Court. So one of them is this. The Supreme Court was not used to receiving tens of thousands of letters. They were not prepared for this. And so the hallways in the Supreme Court were filled with boxes and boxes piled up to the ceiling. And for the most part, the justices weren't all that interested in going through the boxes. So they sat there. The only people, with one exception I'll come to later, who were really interested in opening up those boxes and going through the letters were some of the law clerks who had been interviewing with law firms around the country for jobs. And they were waiting eagerly for their reimbursement checks for their travel expenses. And so at 2 a.m, these law clerks were sitting on the floor, going through these boxes, cursing furiously, looking for their check from some law firm in Los Angeles. The other story, which I find kind of personally touching, is, as I said, most of the justices had no interest in these letters. Justice Brennan, for whom I clerked, had no interest in them. His view was that it's not appropriate for me to read this extrajudicial communication. But one night, about 2 a.m, I went over to Justice Blackmun's chambers because I was working on a case with one of his law clerks, and I wanted to see if he was still there. And I opened the door to Blackmun's chambers, which was partly open, and all the lights were out except the light in Justice Blackmun's own office. And he was sitting there, and there was a green reading light on his desk, and he had a huge pile of these letters, which had been taken out of the envelopes by his assistant, and they were piled up on his desk, and he was sitting there with his feet up on the desk with his reading glasses on, and he was reading these letters at 2 a.m. And it later occurred to me that I believe at that moment, Justice Blackmun began to rethink his views about the responsibilities of the Supreme Court. Because even though appointed as a conservative, Blackmun increasingly later became a justice who was much more liberal in his approach to a range of different cases. And I think at that moment, and the reason Blackmun was sitting there reading these hundreds and hundreds of letters, was it gave him a sense for the first time in his life of what it was like to be denigrated, to be despised, to be hated. And I think he probably took away from that experience an understanding of what it was like in our society to be black, to be a woman, to be gay, that he might not otherwise have related to. So it was a very interesting moment to have seen. Maybe I'm wrong about that, but it just occurred to me that it was a very moving experience. Okay, so to come back to my story, as we know, Roe eventually emerged into a bitterly divisive issue. But this did not happen until the end of the decade, as the culture wars exploded over such issues as the Equal Rights Amendment, gay rights, obscenity, and women's liberation, which inflamed the evangelical community. By this time, by the end of the 1970s, polls showed that more than a third of all Americans identified themselves as born again. Evangelicals had become the nation's largest religious demographic. When the Reverend Jerry Falwell founded the Moral Majority in 1979, he brought together for the first time the many disparate elements of Christian fundamentalism into a single, unified political movement. Falwell explained that if evangelicals worked together, they had the power to take control of the national government. The Moral Majority raised huge amounts of money to support political candidates, and in state after state, its members wrested control of the state Republican apparatus from party regulars. By the summer of 1980, Republican Party leaders were treating Falwell more than any other religious figure in American history, like the leader of a powerful political constituency. The Christian broadcaster Pat Robertson boasted that the evangelical community now had, quote, enough votes to run the country. And in his pursuit of the presidency, Ronald Reagan now called for a constitutional amendment to overturn Roe v. Wade and promised to appoint pro-life justices at all levels of the judiciary, thus ushering in a historic era of judicial nominations shaped in no small part by religious conceptions of constitutional law. With Reagan's election, James Dobson, the founder of Focus on the Family, proclaimed that evangelicals had finally come home, and, quote, home was the White House. In the years since 1980, a succession of Republican presidents have sought to appoint Supreme Court justices who would overturn Roe v. Wade. Interestingly, though, 3 of those 7 justices, Sandra Day O'Connor, Anthony Kennedy, and David Souter, disappointed those who appointed them, demonstrating both a respect for precedent and an understanding of the reality of the experience of women in a world in which abortion is illegal, and an understanding of the fundamental nature of the right at issue in Roe. O'Connor, Kennedy, and Souter consistently reaffirmed Roe, despite repeated efforts to overturn that decision. But having learned this lesson, Republican presidents have grown ever more determined not to replicate this mistake. And with the appointment of justices like Antonin Scalia, Clarence Thomas, John Roberts, and Samuel Alito, the court has now come several times within a hair's breadth of eviscerating Roe v. Wade. So where are we today? Well, had President Obama's nominee, Chief Judge Merrick Garland, been confirmed by the Senate, as he should have been, that would pretty much have locked Roe into place for the foreseeable future. For there would then have been 6 justices on the court who supported a woman's right to decide for herself whether or not to bear a child. Largely to prevent that outcome, however, Senate Republicans, in an unconscionable abuse of authority, refused to even consider Merrick Garland's nomination in the hope that an anti-abortion Republican would win the White House in 2016. If Judge Neil Gorsuch is confirmed tomorrow by the Senate, as he no doubt will be, that will put the court back where it was before Justice Scalia's death. That is, the court will once again be divided 5-4, but still inclined to uphold Roe v. Wade. But if one of the 3 oldest justices on the court, Ruth Bader Ginsburg, Anthony Kennedy, or Stephen Breyer, should leave the court in the next few years for reasons of health, and if Donald Trump appoints another committed conservative to the court, there will then be 5 justices on the Supreme Court who, in my view, will likely vote to overrule Roe v. Wade. In the United States today, 30% of all women have at least one abortion during their lifetimes, and approximately 1 million legal abortions are performed in the United States annually. If Roe is overruled, some states will no doubt legalize abortion, but most will not. Think of the Electoral College. If this comes to pass, then hundreds of thousands of women, mostly poor and minority, will once again be thrown each year into the dark and dangerous world of back alley abortions. So what then is the takeaway of this talk? Well, other than hoping to incite your curiosity so you buy my book, it is to make clear that a world where abortion is illegal is not the state of nature. From the ancient world into the late 19th century, abortion was readily and legally available to women. That was the world the framers lived in. It was the world they assumed would continue because it had never been challenged before. It was only the illegitimate infusion of religious dogma into our secular law that changed all this. And especially in a nation dedicated to the separation of church and state, this is truly a tragedy waiting, I fear, once again to happen. Thank you. So I will happily take questions. There is someone with a microphone, I'm told. I'm sorry. Yes? Okay. Here.
Thank you. I've always understood that one of the criticisms of Roe v. Wade is that it was too much too soon and that activists should only have waited because all the states were on their way to legalizing it. You said the opposite. So where did I get my misimpression from?
So first of all, the opposite is correct. There are people, including Ruth Bader Ginsburg, who have taken the view that Roe went further than it needed to go. That, in their view, all the court should have done in Roe is to say that the Texas statute, which prohibited abortion except to save the life of the woman, was unconstitutional, and not to say anything about when a state might regulate abortion. In other words, to let this play out in a series of cases that would arise over 5, 10, 15, 20 years, and gradually, if necessary, come to the same place the court started with in Roe. And the argument there was that if left alone, the legislative process would eventually have begun to move in the direction of legalizing abortion. So there are 2 objections to that view. One of them is that I think it is wrong. I think it was overly optimistic. I think the fact that the pushback against Roe had brought that movement completely to a halt, and that even today, if you imagine that the Supreme Court overruled Roe, probably no more than 15 states would legalize abortion even now, all these years later. And second of all, the justices were acutely aware of the following. Once they understood, because this was evident in the briefs and in the materials the justices read, the reality of the world in which abortion is illegal, the kinds of stories I shared with you briefly in this talk, much of which was secret, little of which was exposed. It was the women's movement in the late 60s that began to bring this to public attention, what this world really was like, how ugly and dangerous and awful it was. Once you understood that, and once you decided there should be this constitutional right, then to say, okay, strategically, I'm going to let this play out over 5, 10, 15, 20 years and see what happens, which means every year 1 million women are going to be denied the opportunity to exercise this right, are going to be forced into this world of scissors and coat hangers and back alleys. That's not acceptable. That is simply unacceptable. And I think the justices were acutely aware of this. And the idea that they would not do the right thing because it would be interestingly strategic to deny these women this right for 5, 10, 15, 20 years was something that for them, once they understood the reality of the world, was unthinkable. And I think that was exactly the right decision. Yes, over here. Yeah.
Given the status of abortion as you describe it at the time of the signing of the Constitution, how does an originalist like Scalia deny the right to abortion?
So, no, I mean, he would have the following argument. He would say, there is no affirmative evidence that the framers thought that there was a constitutional right to abortion. The fact that it was legal, lots of things were legal that aren't constitutional rights. And what he would say is we should only invalidate laws that we can with confidence say the framers themselves understood and intended to be unconstitutional. And we do not know that the framers thought that abortion should be a constitutional right, because it never occurred to them to even think about the question, because they'd never known of a world in which abortion wasn't legal. And so that would be the way he would answer the question. And if you were a really narrow-minded originalist, that would be a principled way of answering the question. Now, I just want to add to that there is no way that Justice Scalia was in any way a principled originalist. And so a principled originalist would never have found, for example, that affirmative action is unconstitutional, that gun control legislation is unconstitutional, that the Voting Rights Act is unconstitutional, that campaign finance laws are unconstitutional. Nothing in any narrow version of originalism like this could possibly get you to those conclusions. But there is a version of originalism that could be squared with this outcome.
Is there a principled originalist on the court today?
No, there's not. So I'll say a little bit about originalism, because it's obviously an important part of public discourse today. So here's where originalism came from. In the Warren Court, the justices reached a large number of what were perceived by conservatives as liberal decisions that represented judicial activism run amok. In their view, the justices of the Warren Court, whether it was school prayer, or it was Brown and Board of Education, or it was Miranda, or it was MAP, or it was Griswold versus Connecticut, which recognized the right to use contraceptives, a whole range of decisions. Conservatives critiqued the Warren Court, saying that they were not applying the Constitution in any principled, legitimate manner. They had a vision of what they thought was a good society, and they were going to use the ambiguity of the Constitution to impose their own personal values on the democratic process and override what the majority of the people in the United States wanted, and that this was completely illegitimate. And therefore, when Richard Nixon ran for president in 1968, and he wanted to appoint what he regarded as conservative justices, what he wanted was justices who exercised the principle of judicial restraint. And what that meant was that we no longer are activists. We basically give the elected branches of government a high degree of deference, and we only invalidate things in extraordinary circumstances, without defining what those circumstances might be. But it was basically saying we are going to tie our hands now, and we are going to basically give all the benefit of the doubt to whatever the majority wants. Now, principled conservatives like Robert Bork and Antonin Scalia recognized that that was an unacceptable approach to constitutional interpretation. They recognized that the framers of the Constitution intended the courts to play a central role in protecting the rights and liberties of the American people, and judicial restraint across the board would be an abdication of that responsibility. And therefore, they said, okay, what we need is a way, on the one hand, to restrain the temptation that justices may have to substitute their own personal values for the Constitution, and in an activist way override what the majority wants, while at the same time preserving the responsibility that courts have to enforce the Constitution. And the way to do that, they decided, was originalism. So the idea was that courts should only invalidate laws where they can say that the framers of any particular provision affirmatively understood and intended that this law should be unconstitutional. Okay? So an example would be, say, under the Equal Protection Clause, which was adopted after the Civil War, no state shall deny any person the equal protection of the laws. Well, that was clearly designed to prevent laws that discriminated directly against African Americans. So a law that said that African Americans can't serve on juries, that the framers meant that to be unconstitutional. But would a law discriminating against women violate the Equal Protection Clause? Well, the framers didn't think that one way or the other. So an originalist would say, no, that's not unconstitutional. Okay. So here's why originalism is a bad idea. Everything I've said so far, okay, it makes sense, right? There's a logic to it. Here's why it doesn't make sense. First of all, it's completely internally inconsistent, because the premise is we're going to do what the framers wanted. But the framers would never have wanted judges to adopt an approach that was originalist. The original framers were men. They were men of the Enlightenment. They believed in learning. They believed in learning from experience. They believed that society would evolve and that we would adapt over time. And that these vague provisions, that they didn't know what they meant either. They didn't know what freedom of speech was. They didn't know what equal protection was. They didn't know what an unreasonable search and seizure was. These were very abstract terms. They wanted them to take on meaning over time as society changed and as we learned. So originalism is directly inconsistent with originalism. And that's a pretty serious critique. The other problem with originalism is that there are cases where a pure originalist can say the framers did not intend same-sex marriage to be a constitutional right. They never thought about that one way or the other, clearly, right? That's true, right? But the problem is most of the time, we don't know what the framers thought. They weren't trying to spell out what they meant by equal protection, by free speech, by freedom of religion. And so what most judges purporting to be originalists tend to do is to basically say, okay, the framers were reasonable people. I'm a reasonable people. If I were a framer, this is what I would have thought. And so this must be what the framers thought. And lo and behold, you get affirmative action is unconstitutional, and gun control laws are unconstitutional, and the voting rights are unconstitutional, and campaign finance laws are unconstitutional, not because the framers thought that, but because Antonin Scalia thought that. And so the practical reality is that originalism is a great slogan. It works politically, but it has very little real bite in the way courts operate. I'm sorry for taking so long, but yes, how about you over here? I'm sorry, microphone.
Professor, you touched upon Griswold, but it seems to me, Griswold versus Roe, Griswold is the seminal case. Seminal for a lot of reasons, because the justices in concurrence, I always think of, because I read it because of Ed Levy's Elements class, I think it's Goldberg's concurrence about the Ninth Amendment. What does that mean, the Ninth Amendment? And so if you could just expand a little bit, because it seems to me that Griswold is the seminal case. And if you attack Roe, you're indirectly attacking Griswold, and soon you will be attacking Griswold. And
I'll explain all this.
I want to loop one other thing into that. There was a visiting professor in your era when I took your courses, Henry Monahan, who's now at Columbia. And he was talking about this book, which ultimately I read, Democracy and Distrust by, I think, Frank
John
Ely.
John Ely.
And how does that entire thing play into, because it always seems to me a Federalist Society type of notion that they're purveying in opposition to what you just were talking about, fundamental rights, which the framers said it'll evolve over time. And then we also have the 14th Amendment.
Okay, so let me stop there and I'll...
Anyway.
Okay. Actually, it's a very important and interesting set of questions. So, Griswold v. Connecticut, which I mentioned in answer to the question a moment ago, was a 1965 decision. And as I mentioned during the talk, every state had adopted laws that prohibited contraception. You couldn't get information about contraception. It was illegal. You couldn't buy contraceptives. It was illegal. And part of the rationale for this was about the way women were perceived. Women were perceived as Eve-like characters, temptresses, who had a strong sexual desire that men wanted to control, needed to control. And one of the fears was that if women could have sex without the risk of pregnancy, then they would. And they would be unfaithful, and they would have premarital sex, which was seen as immoral. And the question was, how do you keep them chaste? Well, one of the ways to keep them chaste is by the danger of pregnancy. right? And that's why contraception became illegal as well as abortion. Okay, so by 1965, as I also mentioned in passing, most of the states, almost all of the states that had had laws prohibiting the sale, distribution, or information about contraception had changed those laws voluntarily. The society had changed, and people had realized this is crazy, and the laws had been overruled by the state legislatures. But Connecticut was one of the few states, being a heavily Catholic state, that still had laws that absolutely prohibited the distribution of contraceptives or the distribution of any information about contraception. And in 1965, a married couple challenged the constitutionality of that statute on the ground that married couples at least should have a right to contraception in order to control procreation within their families. And the Supreme Court held that the laws against contraception, at least as applied to married couples, because that was the only issue presented, violated the Constitution, that there was a fundamental right of married couples and of marital privacy that the state should not be intruding into. And that was a critical decision that led to, ultimately, Roe v. Wade 8 years later. So the other question related to that was the Ninth Amendment. And the Ninth Amendment is actually important to understand because most people don't even know it exists. So one of the arguments about the Bill of Rights, the original Constitution did not have a Bill of Rights, right? That's why these were amendments, right, to the Constitution. And one of the explanations that the framers gave for not having a Bill of Rights in the original Constitution was the fear that if you list a series of rights, people will assume those are the only rights. But the framers understood that there were lots of rights that they wanted to be protected, but they weren't going to be able to list all the rights that might exist. And so they feared that there would be this negative implication that listing rights would be seen as exhaustive. After they faced objections to adopting the Constitution because of the absence of the Bill of Rights, James Madison came up with the Ninth Amendment. And the first 8 amendments list a series of rights: freedom of speech, due process, no cruel and unusual punishment, freedom of unreasonable searches and seizures, and so on. And the Ninth Amendment says that the enumeration of specific rights in the Constitution shall not be taken to deny or disparage other rights retained by the people. It was designed to make explicit the fact that there are other rights, like the right to marital privacy, right, which hadn't been listed, but which should be understood as part of our constitutional guarantees. So that's where the Ninth Amendment comes into this. And Griswold does lead ultimately to Roe. In 1972, in a case called Eisenstadt versus Baird, the Supreme Court faced the question, what about unmarried people? Do unmarried people have a right to access to contraception? And the Supreme Court said yes. It extended Griswold, saying that individuals have a right to themselves to decide whether to bear or beget children, and that the state does not have sufficient justification to interfere with that freedom on the part of individuals. And then Griswold and Eisenstadt ultimately led to Roe v. Wade. The ultimate question you're asking, though, is if you overrule Roe v. Wade, don't you have to overrule all those cases, right? And the answer that one would give is no, is that in Roe v. Wade, the state interest in regulating the activity is far greater than the state interest in prohibiting access to contraception. And that a state could find, this is a justice saying, not me, a state could find that a fetus is a human life. And who are we to second guess that determination? And therefore we will give deference to the judgment of the state when it determines that human life is at stake here. And that is once you go that far, that's a much more grave issue than anything that's involved in contraception. So you could distinguish overruling Roe from Griswold and Eisenstadt. Now, in Roe v. Wade, the court directly addressed this question. What the court in Roe said is this: the freedom of a woman to decide whether to terminate an unwanted pregnancy, whether to decide for herself whether to bear a child, is fundamental. And therefore, it can only be overridden by a compelling government interest. And this is sort of standard constitutional analysis. And the state of Texas argued, that the interest of the state in protecting the life of the unborn fetus is a compelling governmental interest. And what Justice Blackmun said is that, no, Nobody knows when human life comes into being. Doctors, medical professions, completely divided on this question. An issue about which there is such uncertainty and division cannot be a compelling government interest. And more importantly, Blackmun said, the driving force behind the argument that a fetus upon the moment of conception is a human life and should be treated as a human life is fundamentally derived from religious belief. And in a society dedicated to the separation of church and state, religious belief cannot be a compelling justification for preventing people from exercising what otherwise would be a constitutional right. One more question? I'm sorry, time for one more question. Yes, over here. I'm sorry, I go on much too long, I know. I teach, I can't help it.
It seems that the really basic problem here is the separation of the church and state, which has never come before the courts or the Supreme Court. I mean, in New York State, the Bishops' Council seems to still be pushing for laws limiting the statute of limitation in sex abuse cases. And everybody is bowing, well, the Republicans in particular, to this. So how do we get to a point where we have actual separation of religion and state?
Right. So the Establishment Clause of the First Amendment basically provides that government shall make no law respecting an establishment of religion. And the framers were very concerned about the separation of church and state. It was one of the central precepts that they were worried about, and Jefferson and Madison were particularly engaged with this issue. And what that clearly meant was several things. One is that the state could not literally establish a church. It couldn't have you can only vote if you believe in Christ, or you can only be an elected official if you believe in Christ. The Constitution specifically held that there could be no religious test for public office. And also, it was very clear to them that a law could not be justified by an appeal to religious belief. Okay, but here's the complication. Okay, knowing that a law cannot be justified by appeal to religious belief, people who want to justify a law that is motivated by religious belief will justify it by putting forth other arguments. Right? They won't say the reason for this law is my religion. Right? So, for example, in laws that were against contraception, right, people didn't say contraception violates my religious belief, and that's why it should be illegal. They said that contraception should be illegal because it leads to, if they're available, it leads to premarital, extramarital sex. That's destabilizing for society. It has nothing to do with my religious beliefs. It's a bad thing. And here's where the difficulty for the courts comes in. Courts don't like to accuse the legislature of acting out of improper motives, unconstitutional motives, when the legislature says we're not doing that. Here's the real reason for a law. And even though the justices often know that that's bullshit, right, they are understandably very reluctant to say, no, we don't believe you. Right? We're certain that the reason you're giving for the law is your religious belief. So as a consequence, what happens in reality is that the justices will almost never invalidate a law because they believe it was motivated by religious concerns and values, in the same way they'll almost never invalidate a law that is neutral on its face with respect to race, for example, because they believe the legislature was being racist in passing the law. They won't invalidate it because of the belief that the legislature was trying to discriminate against blacks. Same problem of motivation. But what they will do is they know what's going on. They're not stupid, right? And in assessing the nature of the state's real or purported justification, they will tend to take it less seriously because they'll be more skeptical about it because they do understand the reality. So, and again, in the case like Roe, the notion that life begins at conception, the justices understand that's very much bound up with religious belief. And therefore, that's going to color their willingness to give any deference to the state when it puts forth that as a non-religious justification for the law. But they won't actually invoke the Establishment Clause because doing that would require them to accuse the legislature of lying to them about their motivations. Done or one more question? That means done? Okay, thank you all very much. I apologize.
I wanted to thank Jeff Stone for being here, and we will have a reception upstairs in the Four Freedoms room where you can buy the book, and he will sign it. And I'm told by a very knowledgeable reader of the book that one of the things that went unsaid tonight, and perhaps you can ask questions as you're getting your book signed, is who are the heroes and villains of this book? So there are many more stories to be told during the question and answer than the question and answer period was able to encompass. So we'll have to continue that upstairs in the Four Freedoms room. Thank you, Jeff Stone.